Good morning to everyone at today's public hearing of the Prosecutor Vetting Commission. My name is Christopher Lehman, the chairperson of the commission, and I declare this session to be open. Our commission is established under Law 252 on the external evaluation of judges and prosecutors. Article 22, paragraph 13 of that law provides that this commission will assess candidates for the Superior Council of Prosecutors Selection and Evaluation Board according to the procedure and criteria regulated by Law Number 26/2022 on measures related to the selection of candidates for the position of members in the self-administration bodies of the prosecutors. The hearing is being conducted under the Commission's rules of procedures for evaluations under Law Number 26/2022. The subject of today's hearing is Nicolae Zanevici, candidate for the Superior Council of Prosecutors, Selection and Evaluation Board. Mr. Zanevici, welcome. I'm joined today by my colleagues on the commission. From my right, Nadezhda Hryptievsky. To my immediate right, Virginia Marraro. To my far left, Cornel Lebedinsky. And to my immediate left, Saskia DeVries. And today we have our sixth member of the commission joining by a video link up from his home base in Lithuania, that is Irmantas Mikalonis. I believe as the candidate you can see Mr. Mikalonis on the screen in front of you, and he also is able to see the hearing proceedings. The commission is also assisted by members of our secretariat. This hearing is open to the public and to members of the media. The hearing will be conducted in interpretation into both English and Romanian. I would advise the candidate to speak slowly and clearly when answering questions so that the interpreters have adequate time to do their job. The proceedings are being recorded. The recordings of today's public hearing will be available online on our website within 3 days after the hearings. Mr. Zanevici, during the hearing, one or more members of this commission will ask you questions. I would ask you to answer them truthfully and completely. Your explanations are important to the commission in verifying your financial and ethical integrity. In formulating our questions, we take into account your privacy and, where possible and required, privacy of your family members and close persons. We will strive to leave out any unnecessary details relating to ID numbers, bank account numbers, addresses, and the like. And for your privacy, we would ask that you also leave these numbers out in any responses. At the end of the hearing, you'll be given an opportunity to make a brief closing statement. I will I will start by briefly reviewing the evaluation process for Nicolae Zanevici. The commission initiated its evaluation process on the 22nd of December 2023 by notifying you by email and asking you to complete and return an ethics questionnaire and a financial declaration form. You returned the completed questionnaire and declarations within the allotted time on 29 December 2023. As part of our evaluation of your ethical and financial integrity, the commission also obtained information from a variety of other sources, such as the National Integrity Authority, the State Fiscal Service, the General Inspectorate of the Border Police, and other public institutions, as well as financial institutions and open sources. The commission assesses the information it obtains from you and from these sources for relevance and reliability. The commission also sent you 4 rounds of questions on the 18th of June, the 11th of July, the 13th of August, and the 22nd of August, all of which you responded to. On the 19th of September of this year, the commission invited you to attend today's hearing. At that time, we notified you of the specific topics that would be addressed today. Mr. Zanevici, again, thank you for appearing today. I'll begin with a couple of questions for you. I ask you to respond in a complete and truthful fashion. The first question is whether you need to make or wish to make any additions or corrections to any of the answers you have provided to date to the Commission's request for information.
Good morning, esteemed members of the Commission. I have no additions to make.
I'm sorry, I didn't get the translation. I'm going to ask if the translators can repeat.
Good morning, esteemed members of the Commission. I have no additions to make.
And I want to also clarify the answers that you provided in your 5-year declaration and your ethics questionnaire that were returned on the 29th of December 2023. Do those remain accurate as of today?
Those answers are accurate and valid still currently.
Thank you. I will give the floor at this point to Commissioner Cornel Lebedinsky, who will be following up with some additional questions for you.
Thank you, Chairman. Greetings again, esteemed Prosecutor Zanevici. The Commission will be asking you questions about 2 matters. I will be asking some of them, and along the way, my colleagues will be joining in and asking some questions. Now, the first group of questions has to do with that land plot that was appropriated to you by the local public authorities of Strasheny. And according to the information collected by the Commission in 2007, on your name, an ownership right was registered, and that was ownership over land in the town of Strasheny. Can you confirm this? I confirm. Now, this land plot was appropriated to you by decision of the Strasheny Local Council of December 2006. And Article 38 of the Law on Prosecution Service, edition of 2003, was the basis for that. Can you confirm this? I confirm. According to the decision of the Strasheny Local Council, that land plot was appropriated to you, that was supposed to be meant for the construction of an asset there. Is that correct? Yes, that is correct. And out of our prior written communication, it came out that you did not fulfill that obligation that was set out in that decision of the Council. That is, you did not build anything on that land plot. Could you explain the Commission why that was not the case? The question is clear to me, and I would like to answer the following. I've been working in the prosecution service since 2005. This land plot was granted indeed on the basis of Law 38, and it was supposed to be meant for construction. But in 2005, to be honest, my salary was 375 lei. At that time, the equivalent was of 22 euros. In 2005, 2006, and 2007, there was an intense discussion about the fact that a new draft law would be drafted, a new draft law on the prosecution service, and the guarantees for prosecutors would be enlarged, extended. We were promised that the salary of prosecutors would reach at least the equivalent of the Romanian salaries or EU salaries for that. And I counted on the fact that I would acquire that land plot, and that, as per the promises that were being made by the management, the leadership of the prosecution service, to a certain extent, I believe they too were going to, or were hoping to, retain prosecutors in the prosecution service, because there was a huge exodus of the prosecutors out of the service because of the salaries and the social benefits that were valid at that time. So back then, I did not have the financial possibility to start any construction works. Thank you. In our written correspondence, you've also submitted a report, a geodesic report, that showed that that land plot did not meet the requirements for a construction to be built there. Is that correct? Yes. Considering the circumstances you've introduced us to, why did you not give land plot back, since it was impossible for you to build anything there? And given also that the condition of that land plot didn't allow for a construction to be even built there, why did you not give that land plot back to the LPA, or why did you not ask for it to be replaced for one that would be of such properties that you could have built anything on it? I did not give it back because, according to the legal procedures, that had become my private property. So for me to relinquish it, to give it up, it was supposed to be me giving it up to the government, and that was a lengthy procedure. And I found out about the existence of this geodesic report at the end of 2009, not in 2007 or 2008 when it was drafted. So I found out about it when I've actually started when I became a couple with my wife, that it was in around 2009. And that's when I've started to get more information. I was looking for ways to make the right living conditions for the newly formed family. So I started looking into what documentation was required to be able to build something, what layouts there would be, blueprints. And then when I started doing that, I was told that, look, we can do the paperwork, but this land is not proper for building anything on it. And for me to give it back, I don't know if that would have worked. There is a lengthy procedure to give it back to the government. And then certain things overlapped. In late 2008, early 2010, a procedure was initiated to select prosecutors for whom apartment blocks would be built in Chisinau for preferential prices. Given that if I left things as they were, I wouldn't have been able to make it to the list of prosecutors for whom apartments would have been built, because there was a mandatory condition not to own real estate, not to own immovable property, so that was mandatory. So I decided in that period of time, in that narrow period of time that I had, I thought I would donate it for free, gratuitously, without claiming any rights whatsoever, without claiming any rights or claiming that that is mine. So I decided to donate it to my father because it was not fit for construction. I couldn't have entered into a sale and purchase transaction at the time because its price was almost close to nothing. So I decided to donate it to my father. Thank you for this complete answer. In the context of what you have just mentioned, is it right that you donated this land plot to your father to make yourself eligible for that program between the Office of the Prosecutor General and the Company B in Chisinau municipality, and to therefore later be able to purchase an apartment at a preferential price on M Street? Yes, I confirm this. And I could provide more details of that as required if you agree. So at that time, in late 2009, I've had a discussion with the mayor of the town of Stresheni. At that time, I think I did name him in my answers. You don't have to name the person now. Well, I talked to him. I told him that this land plot was not good for construction. So I've asked what the procedure was for me to replace it with a land that was good for construction to ultimately build something there. The mayor told me at that time that this reserve of land plots was exhausted, that the mayoralty of Stresheni no longer had other land plots to be appropriated, and the possibility for that to be extended or for any such land plots to become available, the chances of that to happen were null. So taking that into account, having considered it, I decided to donate that land plot to my father to have the possibility to participate in that preferential price program. But I can say with certainty that if that land was good for construction, or if they had the possibility or some sort of a promise or truthful promise to be given a land plot in a different part of Stresheni, then I would have certainly not have applied for the preferential price programs. I would not have done it. I am aware that this is not moral, this is not ethical. If you have a land plot to enter into this sort of a camouflaged or formal perfunctory transaction, I think it's not ethical. From my point of view, that wouldn't be ethical. Thank you for your detailed answer. When you've when you've asked the selection commission of the Office of the Prosecutor General, who was selecting the prosecutors and making that list of prosecutors who would be on the list, prosecutors to be on the list to be able to purchase preferential price apartments on M Street in Chisinau. So at that time, did you tell the selection commission that you had already been provided in the past that particular land plot under the law on prosecution service, the 2003 edition? First of all, the Commission was asking for a certificate confirming that I did not have a dwelling or land fit for construction. So a certificate that confirmed the lack of, but they did not ask any questions. So I did not provide any explanations, therefore. Then I got you right. You did not tell the Commission that you have previously been granted that land plot. I did not. Thank you. So what do you think if you hadn't done that donation transaction, if you hadn't donated it, would you have been eligible for participation in this preferential price program for those apartments on M Street? If I hadn't donated it, I wouldn't have been eligible to participate in that program. Thank you. And the last question regarding this block of issues, is it right to say that, well, considering all of the aforementioned, is it right to say that you've used twice programs meant to improve the living conditions that were drafted on the basis of law prosecution service, and so you've been part of these programs of the Office of the Prosecutor General? Formally, yes, but taking into account that land plot was not fit for construction, was not good for constructions, I believe that the answer should actually be no, so de facto not. Thank you for your answers, Chairman. I have no other questions regarding this matter, so if my colleagues have any other questions, over to them.
Thank you, Cornel. I believe Ms. Ruptievsky has questions at this point.
Good morning, Mr. Zanevici. Could you tell us that land plot that you've donated to your father, was anything built on it since then onwards, or how was that donation used after you've donated it to your father? So I am familiar with that land plot. There was initially a decision, but the actual appropriation was later. So there was a decision specifying the area and that that land plot would be given, but then the address was established. I know where that land plot is. And to this day, it's not that there's nothing there being grown, but there's no building. That area is not being used for anything. So that is actually a slope with risk of landslides. So it is not being used in any way. Are there any crops? Are people growing anything there? No. And when you received it on the basis of Article 38 of the law on prosecution service, that is, instead of a government housing? Yes. But your request, so did you ask for a land plot, or did they give you that land plot because they were not able to cover your expenses? Could you please provide a little bit more details? So it was three colleagues of us, we were three colleagues in 2005, 2006 at the prosecutor's office. So back then we were young professionals. We've had a discussion with the management of the Streshin prosecutor's office. We've asked for some housing, some accommodation. It was complicated. We had to be on guard at night too. There were some felonies happening at night, where then some crimes that had to be investigated by the prosecutors at the different times of the day. We needed to be somewhere inside the town of Streshin, not in the district of Streshin. And we were told that the Office of the Prosecutor General is not paying accommodation, not paying rent, and doesn't have real estate, and that we should turn to the local public authorities. So we did go to talk to the local public authorities to raise this issue. We've asked for housing to be granted to us. At that time, the mayor was a little bit of a more advanced age, and he said, I understand you very well, I see, but we don't have it. Streshin doesn't have housing that would belong to the town of Streshin that we could rent out to you. We can give you land plots for you to build something on that. So we just exchanged views, we looked at one another, and then we thought, how would we be able to build anything on it? With what money? But because the prosecutor service was insisting on the fact that there will be better guarantees for prosecutors, the salary will be bigger, you'll have the possibility to take preferential loans from banks, there was this word around. So that's why, well, we thought, let's have these land plots. And we filed for those land plots. Thank you. Mr. Zanevici, can you tell us if you know of colleagues of yours, you said it was 3 of you, were they also granted land plots to build housing, a dwelling space there, and are they close to yours, those land plots close to yours? And are you aware if adjacent to your land plot, are there some other land plots attributed to other people? And what is the situation of other land plots adjacent to yours? There was an annex to the decision, and that annex also covers 2 other colleagues of mine, prosecutors, and then a judge as well, who also asked, on the basis of a request, for housing to be granted to them. Now, I could call them by numbers, I don't know, 52 or 54, so that I don't give their names out. So they are there in that decision. But the paradox is that they were given land plots in a different part, and their land plots were good for construction. And as far as I know, as far as I am aware, one of my colleagues built something on it, and the other colleague sold it. And he sold it, again, I mean, there are details following a divorce, but right adjacent to your land plot were other land plots attributed to other people for building houses, to other landowners, and adjacent to your land plot, is there anything built? According to this deed of ownership, there are some other land plots adjacent to mine that were attributed to people. I don't know how many, but I know that there is. I mean, you can see that there are several land plots in the deed of ownership. But to this day, nothing has been built on those adjacent land plots. Nothing is built there, so it's nothing at all.
Let me follow up also with a question. I'll give you a minute. Does your father still own this land plot?
My father is not the owner of that land. As far as I know, he told me later that he filed an application with court for that land to be replaced with another one.
So do you know what land he got in exchange for the land that you gave him?
No.
I don't know.
Do you know what he did with the land that he got in exchange?
As far as I know, he is still owning it.
So you gave your father a plot of land. He exchanged it for another plot of land that he still owns. Where is this other plot of land, in Stosheny, or is it in a different place?
According to the court decision, my father has initiated this action in court in 2020 or 2021, where he asked for that land plot to be replaced for another. The final decision is from 2022, if I'm not mistaken, and it is within that same town, but it's just in another part of the town.
And so why did he seek to exchange the property?
Well, I can't answer this question, but I've never claimed my rights over that land plot. I've never asked for the equivalent value of that. As my father knows me, knows my attitude towards observing the law, towards having the ethical and moral profile of a prosecutor, he did not tell me about the fact that he'd gone to court. I've only found out about it when there was a court decision issued by the Supreme Court regarding the matter, because he knows how I feel about such issues.
A court decision by the Supreme Court of Moldova?
Yes, the final decision. So there was the initial court, the appellate court, and the Supreme Court of Justice. So all the stages have been gone through.
Just to exchange a plot of land.
He has initiated that civil action, as far as I remember from that decision. So this lawsuit was against the council of the town of Strashen. So that was like a lawsuit against the decision of the district council. Now, the first instance court allowed for that replacement of the land, but the council appealed that decision with the appellate court. And that was rejected. The appellate court rejected it and maintained the first instance court decision. And then the decision of the appellate court was challenged with the Supreme Court, as far as I can remember. So the Strashen District Council took it to the Supreme Court, and the Supreme Court, too, upheld that decision of the first instance court.
That's quite a bit of litigation over this piece of property, isn't it?
Well, that is the procedure.
So did your father need to hire and pay for a lawyer to handle these legal proceedings all the way to the Supreme Court of Moldova to get this new piece of land?
According to court decisions, yes, it appears that there is a lawyer also in those procedures. There was a lawyer involved.
And do you know where in Stashiny this land is?
I don't know.
Obviously, your father must have thought it's a better piece of land.
Well, he's asked for that to be replaced for one that would be such that would be fit for construction, as the first land was initially meant to be but wasn't.
So the second piece of land is fit for construction.
Да.
Okay.
Yes.
Let's see if anyone else wants to follow up on this matter or go on to the next. Or no?
Mulțumesc, domnul președinte. Stimate domnule procuror, trecem la al doilea.
Thank you, Chairman. Now, esteemed prosecutor, we shall move on to the next block of questions that has to do with that decision of 2013 issued by the Disciplinary Board of the Superior Council of Prosecutors, and you were claimed to have committed several violations of the Code of Criminal Procedure and of the Ethics Code. Are you aware of that decision? Do I need to name it, to give it out the number, or are you aware of what I'm talking about? Because of the 2013 situation, and there was nothing else at that time. Yes, I know that about that decision, about the subtleties. Thank you. So my first question is whether you have appealed the decision or not. I have not appealed it. Which means that what was established there, you've accepted it. Those shortcomings, those issues, you've accepted that. I did not accept them, not then, I don't accept them now. Why did you not challenge it then? Well, I would have to provide more details regarding this. In 2012, I was working as deputy head of the Criminal Investigation Department in Chisinau Municipality Prosecutor's Office. At that time, I was part of a criminal investigation group that was looking at a case that was very complex, related to tax evasion, if I'm not mistaken. That's what was there, tax evasion. And this criminal investigation group consisted of 5 prosecutors. The chief prosecutor, who was the team leader of that particular group of prosecutors, 3 prosecutors from the Chisinau Municipality Prosecutor's Office, and a prosecutor from the Botanica City District Prosecutor's Office. What is more, according to that order, a criminal investigation group was also established consisting of several criminal investigation officers. So there was also a group of criminal investigation officers established. And that criminal investigation, I think there were about 62 volumes big when it came to our prosecutor's office. Practically every member of the criminal investigation group had its own, had her own task to address preventive measures, special investigative measures, because we were supposed to have a more segmented or fragmented, staggered approach to criminal investigation to make sure it was more efficient. And as part of that criminal investigation, we undertook a huge amount of work, special investigative measures. We've looked into data, we've looked into documents, we've examined a lot of information, a huge amount of work.
In parallel, as part of that criminal case, I don't know for what reason, a criminal proceeding was registered in relation to some of the companies separately. That criminal proceeding was transferred to me according to the assignment to the register of offenses. And as part of a separate investigation, I asked the National Anti-Corruption Center, I asked the State Tax Service, other institutions, to provide information about those taxpayers, about those persons who at that stage had the status of suspects. Well, we don't have suspects in the legislation, but they were, let's say, suspected. As a result of having analyzed the gathered documentation and having heard several witnesses, I found the lack of elements of a crime for the reason that those companies were checked all the time by state authorities that have not found any violation. For that reason, I issued an order to decline the beginning of a criminal investigation, an order that relied on all documents, evidence that was provided and gathered. Afterwards, more than 10 months later, that order was annulled by the acting Prosecutor General. That is in relation to the criminal proceedings. With respect to the criminal case, as a result of the criminal investigation actions, at a certain point, that case was withdrawn from Chisinau Prosecutor's Office and transferred to the Anti-Corruption Prosecutor's Office, from what I remember. Shortly after that, I was notified by the prosecutor, at that time, a prosecutor within Internal Security Unit, with respect that there is a notification about me with respect to a disciplinary case. I went there, I asked what was the reason in relation to which cases, and he told me that it was in relation to this criminal proceeding and in relation to this criminal case. I asked him, it's 5 prosecutors and we have a lead prosecutor in the group who is actually managing the criminal investigation, and he is leading the members of the criminal investigation group. He issues indications what to do, the solutions issued in the case. Why is it so that only I am the one involved in this disciplinary procedure, and what how might be blamed? Because actions were being carried out completely and in full until it was withdrawn. And during the criminal case, measures have been undertaken, and the solution was justified. It was explained in the order. When I was asking these questions, that gentleman who is mentioned in my answer, he told me that this was not his war. I was astonished. And I asked him, dear colleague, we are working in the prosecutor's office, we are not here at war, we are not conflicting, I don't have any hostile interaction with anyone. I've never been hostile to anyone, I have never had conflicts or any other similar situations within the prosecution service. And the prosecutor had no response to what I told then. During the inspection, I said the same thing. During the investigation, during the disciplinary proceeding, I mentioned all of those details, but neither the inspection nor the board took into account the arguments that I tried to clarify, and I was the only one to be hung out to dry. And the notification and the decision of a board and so on, it's generic. It wasn't concrete, like what exactly was done, what was not done, what were the violations of both the notification and the decision of the inspection, and the decision of the board are rather generic in my opinion. With respect to the fact why I did not appeal or challenge the decision, first of all, according to the conclusion of the internal unit section, the sanction to be applied was a harsh reprimand. That's like one step away from dismissal. Even though before that there was no service investigation to me, no sanction, no objection. I have only been being promoted and encouraged and several times. Moreover, taking into account that prosecutors from the internal security unit were subordinated, both hierarchically and administratively, to the Prosecutor General, I did not trust this possible solution. And in the same situation was for the prosecutors that were part of a disciplinary board. They were career prosecutors. Moreover, if we look at 2013 statistics of appeals and the statistics of decisions annulled by SCP, so disciplinary board decisions annulled by SCP, that indicator was very low. Maybe a few decisions or solutions were annulled. So the lack of trust in the board, in the inspection, and in the SCP made me not to appeal that administrative act. Thank you for your elaborate answer. Looking into this case, yes, indeed, well, this case can be divided into two parts. The period when the criminal case started and where you were a member of the criminal investigation group, but we will focus on the material that you managed. And the questions I'm going to ask you rely, and they're almost word for word retrieved from the text of the findings in the decision, so don't take it personal. I am just going to ask for explanations according to the findings of the disciplinary board. First of all, you improperly fulfilled your job duties by the fact that you examined the control materials between 2011 and May 2012, 9 months, and you only conducted one control action, that was hearing of one person, and that was done in a very superficial manner. Quote closed. How do you comment this statement? I believe this is an erroneous statement, given that the same arguments were made in the criminal case too. It's not right to draw a parallel here, but the same arguments that it was superficially examined, the same thing was mentioned and invoked by the internal security unit within the criminal case. However, within that criminal case, a broad range of criminal investigation measures were undertaken. The amount of work was huge, in my opinion, of course. I believe, well, within that criminal case, I applied all the right due diligence. I examined the criminal material. In my opinion, the prosecutor shall be held accountable for the solution, and the solution issued by the prosecutor has to be justified. And you know, it is paradoxical that the solution is not final, the solution is not irrevocable, it may be appealed, and if you look at the years, orders to decline the beginning of a criminal case or any types of orders, they are annulled by senior prosecutor, by investigating judges, when they do an assessment of the damage. But I have never heard for the prosecutor to be sent to the disciplinary board for issuing a solution like that. At least I have never heard of such situations. Thank you for your answer. I would like to clarify still the fact that the control materials stayed with you for 9 months and there was only one hearing. Is that correct? in that decision, or were there any other actions as well? There were many criminal investigations. We are not talking criminal investigation actions, we are talking about this control material before the criminal investigation. Well, let's call it a criminal proceeding, because it is a criminal proceeding since the complaint or notification. Some various verification was done, asking for information from state authorities that are competent to check the work, to check them in terms of tax evasion or committing violations. I told that before. We requested information from NAC, from State Tax Service, from I don't remember now, well, the documents that the persons provided, so there were criminal investigation measures. Moreover, 9 months. If we look today, according to the legal amendments, we have 45 days to do that. Back then, there was no limited time to issue a solution. It could have been extended. Thank you. Why wasn't this debated then? I mean, because they invoked there was only one measure undertaken. Did you provide the disciplinary board or the bodies that reviewed this case? Did you provide them arguments saying that it wasn't only one action, I did more things? I mean, specifically before, in the period before the criminal case started, I did not submit those materials because after that order was annulled, it was withdrawn from me. It was in the archive. So it was, when it was withdrawn, it was sent to another prosecutor's office, and I did not have access to the materials to provide them the materials, but I mentioned the fact itself. Thank you. Again, let's move to the second question, and I will come with a quote from the decision again. You did not verify the alleged illegal activities of economic operators SC Limited Company and N Limited Company, their economic relations with other economic operators involved in the collection, preservation, and export of ferrous and non-ferrous metal waste and scrap, including their economic relations with delinquent, in brackets, phantom companies, ghost companies. You did not order to verify the documents of these companies. Quote closed, end of quote. How do you comment on this? I told you before as well, a proper verification was done. Again, that's in my opinion. Of course, someone looking at colleagues' file could say that, oh, but that was not done or that was done wrongly. I believe I did it all comprehensively until a solution, a case solution, obviously, because I always support legal and justified solutions. You can't issue a solution on a case just for the sake of issuing. It has to be justified and be relying on the evidence of the case. Last quote from the decision. You did not take all necessary measures to establish the circumstances of the case in order to find the truth, and on May 11th, 2012, in the absence of legal and factual grounds, contrary to provisions of Article 255, paragraph 2 of a Criminal Procedure Code, you issued an unsubstantiated order to initiate criminal investigation, which consequently led to non-compliance with the principle of legality in criminal proceedings. The order to not start criminal investigation was annulled on March 18th, 2013. That's almost 1 year after. So that was the end of the quote. How do you explain what you, especially why the Prosecutor General of a person, the Deputy to the Prosecutor General, annulled your decision to not start the criminal investigation, and they ordered to start criminal investigation on that case? Thank you. Well, currently I don't know what was the outcome of that criminal case because I have no access to it, but I would be really curious to see what was the or what is the solution of the case. With respect to the lack of legal and factual circumstances, that's arguable. The legal ones are articles, specific articles from the Criminal Procedure Code. I can list them, but I don't think they are relevant now to establish my ethical and moral profile. There are elements that are mandatory for an order. They cannot be missing from an order. They have to be listed. And the factual elements are the ones that are the circumstances of the case and the evidence managed by them. So an order cannot be issued without establishing factual circumstances and the reason underlying the order. So I don't have a possibility to provide you with that information because I don't have access to the material. Thank you for your answer. My last question is, well, despite of the number of severe accusations in the decision towards you, the solution was not to give you any disciplinary sanction. And this discrepancy between the severity of accusations and the solution of a sanction that was used raises a logical question. Why, after listing a number of deviations from the disciplinary code and from the criminal procedure code, the end solution was still to discontinue the examination of the case without issuing a sanction towards you? Well, as I said at the beginning of this round of questions, the fact that I was suggested that a harsher reprimand would be issued or applied to me for some violations that, in my opinion, I have not committed, and the fact that the Discipline and Ethics Board decided that there was a violation, but despite the severe violations, alleged ones, the board decided that they should not issue a disciplinary sanction to me. That made me not trust the boards and the SCP. That fact, I think, the Discipline and Ethics Board acted like in Solomon's trial. They were all colleagues. In 2013, back then I was it? By that time I had been working for 7 or 8 years in the prosecution service, give or take, 7-8 years. I just did not trust them. That discrepancy between the suggested sanction and the solution adopted, and the fact that they did not take into account, did not analyze the arguments that I provided, that made me not to appeal. Thank you for your detailed answers. Chairperson, I have no more questions to the candidate. Maybe the colleagues do. Please. Mr. Zanevici, only if there are such statistics or if there are none, I understand. But could you please comment how often, and is this a phenomenon in the prosecution service, that the orders of declining the beginning of criminal investigation are annulled 1 year after the fact? Is that a reasonable timeline from your point of view? Is that a constant practice, or are those rather exceptions? And the annulments take place sooner, so to say. Could you comment on that, please? I do not have any statistics. I don't think that the prosecution service has any about the timeline of annulling solutions. But from what I know, and based on my 19-year practice now, the orders or solutions are annulled within a very short time frame. 15 days for appeal, and then 10 days for appeal, and 15 to solve the request. So that makes it 1 month. Well, an exception is 2 months when the person did not have a possibility to be informed of the solution within the established timeline, and then it can be extended. But I have not encountered that long of a timeline before. So in your case, could you please explain, was it your high-ranking prosecutor who annulled it, or who did annul it? How did that annulment take place? Could you please provide any details if you remember? I mean, the one that was 1 year later. Did I understand that correctly? That's from documents I saw. It was like 1 year after you issued the order declining the initiation of criminal investigation. Another order was issued to annul your order and to start the criminal investigation. I don't know if it was an order to start criminal investigation. From what I remember, from the report, from the disciplinary proceeding, there was an order of the acting prosecutor general, if I'm not mistaken. The acting prosecutor general at that time. So it wasn't just the higher ranking or chief prosecutor of a unit. It was the acting prosecutor general at that time.
Do you have any further questions then on item 3? Completely. Okay. Then, at this point, Mr. Zanevici, let me give you the opportunity to make any kind of closing statement that you would like to the Commission.
Thank you. I would like to thank you for the Commission for the effort made. I would like to thank the Secretariat. And using this opportunity, honestly, I just want to thank my family for supporting me fully and over the years. Because thanks to them, I became who I am today. I am aware that this procedure is not a comfortable one for candidates, but it's a rather necessary one for the prosecution service, for the justice sector altogether. You know, as much as uncomfortable and unconventional it is, it's still necessary. During my work, I made effort, I tried to keep the image of an impeccable prosecutor, a prosecutor that would be an example for the others. I don't know how good I managed to do that, because that's to be decided on by the ones who see me every day, by the ones who I work with. So again, I thank you for your effort. I wish good luck to my contact candidates, well, colleagues that try to become part of this board. I wish you all peace and best of health. Thank you.
We thank you for your participation today in the evaluation process and at this hearing, and the Commission will now deliberate on the matter and issue a decision, and I will declare the hearing to be closed.